Judge Perry today basically telling these lawyers that it's going to happen. We're going to get this jury. We're going to do it. I'm going to get 12, and you're going to have an opportunity to strike them. You don't strike it, I'm swearing in those 12. And we're going to keep moving forward. Joining me tonight to talk about all this in Clearwater, Florida, Gene Casares for In Session on True TV. Criminal defense attorney Mark Eiglarsh is in Miami. You can hear more from Mark at speaktomark.com. And criminal defense attorney Richard Hornsby is with me right here in Orlando. Gene, to say that Judge Perry is determined, I think, is putting it mildly. Judge Perry is pushing these lawyers to get those jurors, and the manner that he's doing it, it seems like it's a lot more plausible that we may very well have opening statements early next week right here in Orlando.
You know, Vinny, it is going quickly, and one reason it's going quickly is the judge is actually passing jurors along to that final selection that one might think he might not. For instance, there was a female who said, I cannot judge someone who talks and judges someone else. I can't do it. Jeff Ashton said, well, that's the whole point of a juror, that someone that listens to what someone is saying about someone else. She also said that she thought she could impose the death penalty, recommend it. Well, prosecution wanted to strike that juror. She was African-American, and the judge did not believe there was a race-neutral reason, so he disallowed that strike from the prosecution. The defense is going to want this juror, and she's going on for final jury selection.
Absolutely. Richard Hornsby, when you think about the process that the judge is using here, it seems like it is one that kind of puts the onus on the attorneys to be careful about exercising their strikes. I mean, because he's going to put someone in there, they have no idea who's left in that pool, what's going to show up next.
Well, and that's where the whole strategy of jury selection comes in. I want to go out on a limb here. I don't think they're going to finish very soon like Judge Perry wants. It's going to take at least another 2 or 3 full days. There's 19 more strikes out there. There's 19 more people that either side total can strike. And so, yes, Judge Perry is putting the pedal to the metal, but he's got to do it within the law. And with all these strikes out there and the strategy that's still left, and then you're going to have more for cause challenges re-raised, I think it's going to take a long time, and it's going to really frustrate Judge Perry.
Well, 2 or 3 days, I mean, 2 days puts us on schedule because he can work Saturday. Mark Eiglarsh, he has no problem working on Saturdays, Judge Perry. He'll put in a full day and potentially on Monday, and then we'll be ready to go here on Tuesday.
Sure, move it along, Judge Perry. The problem is you've got the rights of the defendants you got to worry about. And also, you got to give the state a fair trial. When the state alleges that somebody has difficulty sitting in judgment or may have difficulty imposing the death sentence, that is, here in Florida, a race-neutral reason where a strike should be allowed. So in his zeal in moving this case along and his desire to move it along, which I want to, he needs to be very careful not to infringe on the rights of either the state or the defense.
Well, Richard, how about that? If this thing's being pushed along, does it give an advantage to one side or the other? Because Mark just pointed out one instance that doesn't really help the prosecution, and I'm sure there's one that's occurred that probably doesn't help the defense as much.
My personal opinion is that if it's going to help anybody push this along, it's the state, because they've already got people that are willing to impose a death penalty. Because here's the bottom line. Sure, the state has a right to a fair trial, but they are not going to appeal his denial of a race gender neutral challenge right at this point. So they're basically stuck with his ruling, and the only way it's going to get readdressed is if Casey Anthony is convicted. So that's not really a big issue in Judge Perry's mind. The bottom line is that if it's going to help anybody, it's going to be the prosecution, because all they need is 12 people that are willing to impose a death penalty, and they've got 90% of what they need.
Gene Casares, you know, as they work deep into the night and as they keep pushing this forward, working all day Saturday, not going to work on Sunday, though, right? But they could return on Monday to Pinellas County.
Yeah, definitely. Now, let me tell you, a lot of jurors have been ambivalent on the death penalty. I haven't really thought about it. Well, I think I could. And they have been passed along, and they are going into this final pool. They have not really conclusively said, yes, I can recommend death. It's just sort of iffy, but they keep going. The judge passes them through.
And Mark Eiglarsh, the prosecution here, is it all about the death penalty, or is it about a conviction here?
Well, it's about both, but I got to comment on what Gene said. When these people are saying, I think so, that's not enough under the law. If you ask a pilot, do you think we're going to make it to New York or a destination? He says, yeah, I think so. That's not going to be too reassuring. They need to say yes. And if they can't say yes, I don't think that you pass them along.
And Vinny?
All right, we'll have more
Vinny,
in-depth coverage of the Casey Anthony. Oh, go ahead, Gene.
Vinny, here's what they're saying. They're saying in serial killer situations, dismemberment situations, they're giving examples of where they think the death penalty is appropriate.
All right, we'll have more in-depth coverage of the Casey Anthony trial throughout the hour. One piece of evidence that will definitely play a huge role in this case is the alleged smell of death in the trunk of Casey's car. George and Cindy Anthony have talked about it. Experts have talked about it. The defense tried to get air samples taken from the trunk thrown out as evidence, but earlier this week, Judge Belvin Perry ruled those samples can be allowed in the case. Well, here's the stunner now. Jurors may get the chance to smell those air samples. My panel is back with me. And my goodness, G. Casares, just to get everyone up to speed on this issue, the judge still has to decide. He was originally saying no, right? And now he's saying, well, you got to convince me to allow the jurors to smell these cans.
He has been ambivalent from the beginning. I mean, he did say this is opinion testimony, but this can't be a surprise to the defense because in one of their motions, the motion to suppress this type of evidence, they talked about the sealed tin cans that the prosecution has. And right then I said to myself, whoa, could they want to open one of those for the jury?
Mark Eiglarsh, how about that? And, you know, it's one thing when you've got person after person after person describing this smell, right? But having the jurors themselves use the sense of smell, open one of those cans that's got the piece of the lining of the trunk of Casey's car that's been sealed in there, fermenting for all these months. That's powerful evidence.
Absolutely. They will never forget that smell the same way the other witnesses are saying the smell of death you'll never forget. It's compelling, and I do think the judge should let it in. Let it in and let the jurors give it the weight they want. Not make the determination on their own whether that's consistent with a dead body, but wow, it's a powerful smell. That's how witnesses are able to testify that it's so unique that they know what it is.
Nancy's in Florida tonight. Good evening, Nancy.
Good evening. Believe me, no one forgets the smell of decomposition once they've encountered it. The defense will have a hard time trying to get George Anthony to backpedal on his claim of the smell of decomp in the trunk of Casey's car. He was a police officer. He knows that smell well. He was not mistaken.
Nancy, how would you describe that smell versus maybe walking past a dumpster full of rotten garbage?
It's really difficult to compare the smell because there is no smell like it. It is nauseating. It is sickening. It stifles you, and it takes some time to get used to working around it. You often see, you know, people say they're going to put Vicks under their nose or they have a cigarette or a cigar if they have to work around it. It is really overwhelming.
Thanks for the call, Nancy. Appreciate it. Richard Hornsby, how about it? Actually taking these cans that have been sealed since Dr. Voss put those cuttings in there and then open them for the jury. How would you even do it? Would you do it in the courtroom?
That's the thing. There's no decision right on point on whether this is even appropriate. And Judge Perry nailed the one issue is you can't make a juror a witness in the case to decide what that smell is or what it isn't. And that's a big issue. But I would only think that the prosecution literally wants to hand them that canister and let them unseal it for themselves and just see that look. Because the minute they smell that, whatever sympathy they may have had up to that point for Casey Anthony will just evaporate immediately if the smell of death comes out and all they can think about is Kaylee.
Unless,
Mark
Vinny, unless
Go
the defense concedes that the body was in that car and that their theory is and should be that the child died accidentally and that she panicked. Don't kill the messenger. This is what I would argue. And since opening statements are right around the corner, I'm gonna give it out. She drove around with the body in the car for a while, panicking, not knowing what to do, and she chose to then put a piece of tape over the mouth and make it look like someone had taken the child, and then ultimately, that's what I think is her best chance of ever tasting freedom or getting a lesser charge. Concede the body was in the car.
I agree. Mark, I agree 100% with you. We could open up the law firm of Politan and Eiglarsh. I was going to say Eiglarsh and Politan. No way. It's going to be Politan and Eiglarsh.